Get on with our presentation. We are now here to talk about what we parents worry about in terms of keeping in-laws from becoming outlaws. I personally learned this phrase from Mr. Bob Vale here, and I love it, and I use it on a daily basis. And it's great because it's the perfect description for what you're trying to achieve. These lovely folks here are the same that you see on your screen. Just a quick photo, but what I really wanted to get to is to Joanna. She is our guest speaker here today. Joanna Wald is a family law attorney with Viola Law Firm here in San Mateo. Ms. Wald handles family law matters at every stage of the process, including premarital agreements, post-nuptial agreements, complex divorce settlement agreements, negotiations, spousal and child support matters, which are never easy, as well as breaches of fiduciary duties between spouses and child custody and domestic violence matters. So it is my great pleasure to have Joanna here as our guest today, because she's going to do a deep dive in terms of what it means in the family law world to keep in-laws from becoming outlaws. Thank you for joining us, Joanna.
Thank you so much, Roxanne.
Thank you, Joanna.
All right, so why are we here? Probably because we're concerned about these cuties here, right, Bob?
I think so. Our kids, yeah, that's who we're focusing on today. Although we will be discussing, all the way through later in life, but certainly focusing on the kids.
And a lot of times when we have clients coming into the office and they happen to have children, what they'll say to us is, I want to create a trust for my kids. I want to, put all of my assets in trust for my children. And I almost have to take them a step back and say, yes, you have children, but first and foremost, when you're doing your estate plan, before we even get to your kids, the first set of beneficiaries that we're taking care of are the parents. Okay. So the children may be the apples of our eyes, but we still have to take care of ourselves first.
That is such a good point, Roxanne. You're right. A vast majority of clients coming into the office to work with us on their estate plan, they want to know how to make sure to get everything to the kids as easily as possible. They don't think of themselves. No. What we can do for them. Yes.
So selfless. So selfless.
Absolutely.
And then if we have those children who are getting married, one of the easiest ways to, I say that it's really probably not that easy to have that conversation about prenuptial agreements. But a prenup for our children might be appropriate if we're trying to protect our family assets. Okay. But we're also protecting our children from creditors and predators. And divorcing spouses might not be the only set of folks, but if we are trying to create an estate plan for our families that will in the future protect our kids from creditors and predators, we can achieve that through estate planning.
Stephanie Coggins, who, was with us for many years and has moved up to Sacramento, used the term bubble wrapping the inheritance. And I really like that, bubble wrapping the inheritance, because I know, Karishma, you like to use that term. It's one that we can relate to. Oh yeah, let's bubble wrap that inheritance and move that down so that we can protect our kids. Just to, it's not bulletproof, but we can protect our kids from creditors and predators from being able to reach in and grab the assets that we've worked so hard to accumulate and leave to our children. We really don't want to see those going out of the bloodlines or going to, creditors that we're not anxious to pay off for the benefit of our kids. Yeah.
I love that. Bubble wrap. I'm going to borrow that.
Yes. Attribution to Stephanie.
I will. Thank you. So what about folks that are marrying later in life? Do they have concerns, Karishma and Bob?
They do. They most certainly do. Maybe even more concerns than younger people getting married.
These people have obviously invested a lot in plastic surgery if they're late in life.
Some excellent surgery.
Yeah, absolutely. We'll be taking a look at some of the things that we can do for couples marrying later in life. And there are a lot of moving parts there. Probably some of the more complex planning we do addresses that situation. Yeah.
All right. So marrying later in life is something that we needed to consider too. Well, what about if divorce is in the cards? Families have assets and they're divorcing. Can we do anything for these folks?
Yeah. Sounds like we'll be working with Joanna if that comes up. Huh, Joanna? That's the time when you're going to start coming into the picture, huh?
I'm ready.
And oftentimes when we have assets, we probably have assets that have beneficiary designations on them. So if whether it's, creating an estate plan and you're still married, you want to update your beneficiary designations to reflect the people that you want your assets to go to. If you happen to be divorcing, then you may want to try to update your beneficiary designations if permitted, because there are some limitations upon the filing of a dissolution proceeding. You can't just change all of your beneficiary designations. But then after the divorce is over, it's probably something that you should definitely look at.
Yeah, and I think every presentation we do, we bring up beneficiary designations because it's something that that when we as administrators of trust, when we're working with the administrators, if somebody hasn't updated their beneficiary designations and there's nobody named, often the default designation is the estate. And when we talk about the estate, we're talking about probate. So an asset that should move like that ends up going through a 9-month probate process. And that is a very bad result for everybody. So beneficiary designations often are overlooked and turn out to be a very important part of an estate plan.
Mm-hmm.
And speaking of parts of an estate plan, we can actually structure an estate plan so that upon the death of the first spouse, we can put in place more bubble wrap to protect the surviving spouse, whether it's because of separate property assets, whether it's because we have a blended family situation. In some blended family situations, you have children from different marriages or relationships, and maybe the asset allocation is going to be different than an otherwise just standard nuclear family that's not blended. So protecting the surviving spouse is certainly something that can be achieved through the estate planning process. Well, there's all these things to consider. What are some possible solutions?
Here we go. Now we're on to the solution. So that's good. So that's good. That kind of gave an overview of what we're going to be talking about. Now we're going to take a little bit of a deep dive and provide some solutions for various scenarios, huh?
That's right. So for our kids, we can consider those prenuptial agreements before marriage.
I hear Joanna does those.
Oh, that's fantastic. It's what a coincidence we're doing this topic today. And then we can also, in the estate planning, we can create lifetime trusts that ensure that assets will remain in the bloodline once they're passed to the children. So perhaps I would love my in-laws, but maybe probably not so much that I would want them to take half of everything that I leave to my sons. So I could put together an estate plan that keeps their assets separate from their spouses or future spouses and passes on to their children. So my grandbabies, you heard it here first, my grandbabies are getting everything. So we'd like to deep dive and talk about some of the family law solutions that Joanna can help our clients with.
Yeah.
Yes, thank you so much, Roxanne, and good afternoon, everyone. As Roxanne so kindly pointed out, I am an attorney here at Viola Law Firm in San Mateo County. I do specialize in doing prenups and postnups. While there are lots of family law attorneys in San Mateo County, not all of them do prenups and postnups. So I think that's a misconception. You want to make sure you find somebody who actually has experience in drafting. And before we dive into prenups and the legalese of all of that, I wanted to take a step back and think about, who would want a prenup and what do we know about prenups and postnups? First of all, prenup, as the name denotes, is before you get married. A postnup is any time after you get married. It could be a week, it could be 10 years. And so either are available. The most famous case here in Northern California, one of our Bay Area heroes, Barry Bonds. Some of my colleagues will remember reading this case in law school. It was probably my most exciting time in law school to be able to read about this case. It was actually handled here in San Mateo County by a colleague of mine who is still practicing. This is the famous case about the wife who did not have an attorney and the wife who was went into the marriage with a husband who wasn't making very much money, $150,000 to be exact. And fast forward, I think it was 7 or 8 years later, we all know how well Barry Bonds did in his career, was making a whole lot more money. And so the question became about, consenting to the waiver of having an attorney and understanding what you're entering into. And did we have fair bargaining power, right? Is somebody that English was their second language, less formal education, not having an attorney, all of these things became very important questions for the Supreme Court. And so that is often where a lot of our legislative ideas and new laws come from, right? So we've come a long way from the Bonds v. Bonds case. Now, generally speaking, most attorneys that handle prenups insist that the other side is represented. I personally will not do a prenup where the other side is not represented. So that's step one, right? Finding a great attorney for both spouses. And step two is, why do we need a prenup and do we need a prenup? My, again, personal opinion, everyone needs a prenup. I don't care if you don't have a house or if you don't have a 401k, you are simply purchasing peace of mind, right? You're purchasing peace of mind for yourself and for your immediate family members. And so I often get asked by clients who do not have a vast amount of wealth, obviously here in the Bay Area, that's relatively speaking, do I really need a prenup? And the answer for me is usually yes, right? Because we can limit things other than just your current assets. And so the next question is, what is included in a prenup? What can I actually do with a prenup? You can, insert terms about spousal support. California spousal support is extremely complex. It is, probably the biggest part of my practice is dealing with spousal support. You can designate how income is treated during the marriage, right? Do we want all of our income to be joint or do we want it to remain separate? Most importantly for this group, you can designate how property is characterized, right? Do I want my separate property that I'm bringing into the marriage to remain separate, or do I want it to become community property? Also, a huge piece of a prenup can be waiver of inheritance rights. So parents with children from a previous marriage who want to make sure that their kids inherit their assets can actually ask that their new spouse waive their inheritance rights to those assets that would otherwise follow to them. And so really a prenup can cover all aspects of a divorce, right? And so it is helpful to have an attorney who is a litigator like myself, right? Somebody that goes to court and sees what the court is likely to do with these assets. What is likely to happen with, a property that you own in Oregon before marriage? What is the California court in San Mateo County going to do with that without a prenup, right? And that way we can sort of plan for those scenarios. When we're talking about spousal support, not necessarily related so much to your estate plan, but extremely important in that if you're in a long-term marriage, which in California is generally 10 years or more, and you are the higher earning spouse, you are looking at paying a substantial amount of support to the other party. Doesn't matter your gender, doesn't matter your income necessarily. If you could be making $200,000 a year, you could be making $10 million a year. Both of those people are looking at paying support so long as there is a disparity in their income between themselves and the spouse. And so these are all things like an estate plan that you can decide before you get to that time when there is a consequence, AKA divorce, of how you want these areas of law to be treated so that California courts are not dictating, right? Do I want to limit my support so that it makes sense for San Mateo County, right? We know how expensive it is to live here. Do I want to limit my support so that it makes sense with our rental values, with the housing market, not just the arbitrary numbers that the court comes up with? And then it also, many times when you're entering into a new marriage, or even, you've been in a marriage for a few years, you're blending not only your spouse's, maybe children, but also their extended family, right? And so you have that opportunity to have those discussions early on and maybe give mom or dad, grandma, grandpa, peace of mind, right? That their business that they've worked the last 100 years on is going to stay in the family, right? That is something that we can mirror with the prenup, right? So that everybody's on notice. Part of the process is both spouses do financial disclosures, right? You lay everything out, all of your assets and debts, so that everyone is informed. We can list the trusts. I've done this with Roxanne before in a way that it's distinct enough that the parties know what you're referring to, but you're also giving, privacy about the values and the specifics of the trust, but that it will stay separate, right? And then everyone's on notice. It mirrors the estate plan, and it's signed, and we all cross our fingers, right? That should the time come that premarital agreement is upheld, and we go from there. And so that's sort of my spiel. Obviously, prenups and postnups can become quite complicated depending on the complexity of the party's assets and debts, or they can be very straightforward. Either way, it's recommended, especially if you're doing an estate plan, that you do them together.
So Joanne, what I'm hearing is, and I often go over this with clients when they come and see me, and then I suggest maybe that they consider it might be a prenup because they're thinking of getting married, or a postnup. And I get to tell them, and in that way, you won't just be dealing with me, you get to deal with two other lawyers. So yeah. that is an issue, but I think I follow what you're saying. It's this is my pitch, and I don't know, it may sound crazy. I'm an old guy, but we marry for love, and we want to marry for love. And if we have that agreement, that really takes the asset equation out of it. We have an agreement on that, and then we can marry for love and go forward. I probably sounds really old-fashioned, but I do think there is some merit in that view.
Absolutely. And I often give my clients ideas about who to blame. Blame the crazy uncle, blame the your friend from high school became an attorney and he's really recommending it, right? It doesn't have to be about, I just don't want you to have all of my money, right? That's not necessarily what it is about. It is, in my opinion, it is very similar to an estate planning document, right? It should not be seen as contemplating divorce, right? That is the biggest discussion I think that is hard for people to have with their fiance. Is, you're intending to write this because we're going to get divorced. And that's just not the case, right? It is to take that power away from the state, and have your assets treated the way in which that you want them treated.
Thank you. Thank you.
I love it. And it's really, plan for the worst, but live your life for the best.
Yeah.
Defeat Murphy's Law. That's
Murphy's Law. Yes. Thank you so much, Joanna. That was incredibly helpful and educational. So for anybody who is in the contemplation of dissolution or dissolving their marriage, some solutions, Joanna did cover some of this, is, agree with a spouse to dissolve any existing estate plans. And so we were chatting earlier before this vlog, and if the two divorcing parties stipulate and agree to dissolve their trust together, and they can move their assets in a reasonable fashion, and they all are on board with that, that's okay. And you can have new estate plans during the pendency of divorce. Or, to the extent possible, you can create your own estate plan that articulates what your wishes are, even if you're not yet divorced, and even if you cannot yet move assets out of perhaps a joint trust. Okay, just have that vehicle ready.
And I like to think about, and Karishma, this is something we talk about, is, the powers of attorney for healthcare. I mean, if you look at your advance directive, do you really want your spouse, who's typically the divorcing spouse, do you really want that person to be in charge of your medical care? Probably not. And you have a durable power of attorney for finance as well. Typically, the spouse is named primary, so you probably want to update that. So there are, there's things that can be done right away that are not in violation, but you're going to tell us, Joanna, that we can't be swapping out beneficiary designations, right? On our own, that is.
That's right. Yeah. Once you file for divorce in California and the other party is served, there are automatic temporary restraining orders that go in place in terms of your assets. You cannot encumber, transfer, lien against, anything like that, sell, and that includes changing beneficiaries. So working with an estate planning attorney during that time makes a whole lot of sense, because then we can get everyone's consent. And again, it can mirror the estate plan or trust.
Yeah. And that's, yeah. And just from our standpoint, Joanna, that's how we typically will collaborate with you as the dissolution process continues. We're involved updating documents, hopefully getting stipulations if the parties are amenable to stipulations about, updating beneficiary designations and the like. But that's, yeah, that all depends.
That's right.
Thank you so much. And some of the other possible solutions with regard to, making sure that assets stay separate for blended family situations. Well, some of our clients consider the use of something called a control trust. Now, it may not help with when it comes down to, saving on estate taxes, but the deceased spouse could control assets from the grave through an estate plan.
Yeah. And of course, when we're doing that, we're typically controlling a deceased spouse's separate property. And of course, if they have that prenuptial agreement or a postnuptial agreement, it's going to be better defined, right, Joanna? Because what we don't want to do is have a dispute about, well, that's really not separate property. That really is a community property asset at that point. And that can be I could see how that would be a trap, a problem.
Yes. So between the estate plan and the prenuptial or a postnuptial agreement, it's like layers of an onion of protection, just layer after layer, just reinforcing that inner membrane of that onion.
Yeah, good point.
We can also create trust with remarriage restrictions. If we provide for a spouse in the event of one spouse passing away, but if I die first and my husband remarries, well, I don't need to support cruise ship Irene. If he remarries, he's done. No more. And I just made up cruise ship Irene. There was no cruise ship Irene, I promise.
I like the term though. It's almost as good as bubble wrapping.
And we can also put in place trust with distribution trustees, so that there's another layer of protection, another person to go to say, all right, can we make a distribution in the event of a need? Well, it's just one more person that can provide that level of protection of those assets.
And I know we're running out of time, but I want to say that, a lot of this control issue, when you get to be, you say gray, I'm going to say silver haired like me, what happens is you start thinking about what happens if I become, less and less competent and more open to undue influence. This is a great time to have these, even in marriages, long-term marriages, my wife may be concerned about, how things are going to go. If something happens to her, what's Bob going to do with the assets, when he becomes feeble and, and not so mentally attuned. So having those restrictions or control trusts in place can be important for families that are otherwise they're not blended,
Exactly. And you can use family members as co-trustees to help assist and make sure that the assets are going to the beneficiaries that the spouses agreed to.
Right.
Now, sometimes we may not want to use family members as trustees, but in those cases, we can explore the nomination of professional fiduciaries, people who do this for a living, and all they're doing is following the letter of your trust document and making sure that those wishes are adhered to. Even institutions like large banks would have their own trust departments that can facilitate the same.
Well, Roxanne, we have once again done as we want to do. We are talking attorneys, and we had all that great input from Joanna. We're out of time, so we should maybe see if there's any questions. Do we have any questions, Morgan?
No questions at this moment.
Oh my gosh. Okay, it was so clear. All that so clear, that complex subject just distilled into this completely understandable thing. Well, that's good, because we've got a minute left. Joanna, would there be anything else that you would like to offer?
Oh,
how does a postnup, one thing you didn't touch on is how does a postnup compare with a prenup? So a postnuptial agreement versus prenuptial agreement. Maybe I would like to hear that.
No pressure, 60 seconds, right? No.
Elevator.
Yeah, like I said, the what can be contained, how the process goes is identical, right, for a postnup. The only difference is the circumstance of the parties. You're now married, right? And your fiduciary duty to one another is a bit different as spouses, right, than as you were prior to marriage. But in terms of, you know, what you can and cannot change the characterization of, what you can limit on spousal support, what you can waive in terms of inheritance rights, all of the same. And so oftentimes there's a bit more worry before marriage to do a prenup. Maybe you've gotten more comfortable during your marriage. Maybe you've, you know, ascertained more assets. So it's never too late, right? The process is going to be the same. We can still mirror your estate plan. Maybe you're updating your estate plan, and at that point you realize you need to do a postnup. It's never too late.
Perfect. Thank you.
Beautiful. And that brings us to the end of our presentation. Joanna, thank you so much again for joining us today and bestowing your amazing breadth of knowledge on family law with us in our audience today. Morgan, thank you for coordinating all of this. And thank you to my fellow McDowall Cotter speakers.
Yes. Thank you, everybody. Thank you for attending. Thank you, Joanna.
Thank you for having me.
Thank you. Bye.